In our final case this morning, 2025-0791, in the matter of the Dayton Bar Association versus Christine Marie Baker. Joining us today is Judge Eileen Gallagher of the 8th District Court of Appeals, sitting for Justice Bruner. Judge, thank you for saying yes today.
Thank you.
We appreciate your service. Ms. Baker, good morning.
Good morning, Your Honor. Chief Justice Kennedy, and may it please the court, my name is Christy Baker, representing my own interests in this matter. I'll begin by reading you two short passages, summarizing my arguments briefly, and I'd like to reserve whatever time I have left for rebuttal. Passage 1. Earlier today, your employee, Zach Reynolds, advised via text that he's refusing to return $550 accidentally transmitted to his Charles Schwab account via Zelle. I am attaching his message. Is Mr. Reynolds' conduct consistent with your firm's values? Christy Baker. Passage 2. This is not in the court's record. It is from Stanford v. Northmont, case number 319 CV 00399. Document number 111, page ID 2768 in the Southern District of Ohio. Attorney, excuse me for speaking too loudly into the microphone. What do you consider your race to be? Teenage witness, black. Attorney, in this case you alleged that you have been discriminated against because of your race, correct? Witness, yes. And you have called yourself black earlier, correct? Witness, yes. In fact, you are multiracial, correct? Witness, yes. Attorney, your mother is white and your father is black, correct? Witness, yes. Attorney, but you would agree, and I think your mom already talked about this, that your skin is actually very white, isn't it? Plaintiff's counsel, objection, irrelevant. Attorney, do you disagree with that statement? Witness, yes. Attorney, in what way? Witness, my skin isn't very white. I'm light-skinned with black people hair, so I don't look like a white kid. Plaintiff's counsel, objection, this is irrelevant. Attorney, just trying to understand. Are you saying you don't look like the white kids because of your hair? Passage 1 is the email I sent to coworkers of an Illinois resident named Zach Reynolds, who shares my husband's name, after he refused to return money I accidentally sent to him via the payment platform Zelle. Passage 2 is one of the times that a then member of the Dayton Bar Association's Certified Grievance Committee attacked, threatened, or humiliated families in a civil rights action. Passage 2, not passage 1, occurred in the context of the attorney-client relationship. Passage 1 has been the basis of the Dayton Bar Association's efforts to disbar me. Almost 5 years ago, the speaker in passage 2 told me that she referred my initiation of the Northmont matter to the Dayton Bar Association. Almost 2 years ago, Zachary Reynolds of Downers Grove, Illinois, issued a lie-filled grievance to the Dayton Bar Association. Around 22 months ago, a member of the DBA's Certified Grievance Committee erupted into a rage in a closed conference room occupied only by him and me. What did I do or say to cause this man to stand over me in rage? I asked him if he was threatening me. Excuse me. Almost 20 months ago, I complained to the Dayton Bar Association about its professionalism CLE broadcasts, in which grievance panelists repeatedly referred to Greene County, Ohio probate judge and his daughter using pejoratives that are in my objections that I won't repeat here, publicly mocked and imprisoned attorney's alcoholism, saying, quote, "Is he still making hooch in the toilet?" Joked about its members' sex lives, discussed privileged information with the lawyer of the jailed attorney I just mentioned, made fun of pro se litigants and people with court-appointed attorneys, suggesting that they cannot write their names.
So did you grieve all of them? Have you filed grievances against them? You're alleging professional misconduct. We all have a reporting duty.
I submitted.
So I want to really talk about your case and
Sure.
the allegations here.
Yes,
That's what
ma'am.
we're here to talk about.
Please.
So let's talk about your allegations and why you believe they're wrong.
Okay. My allegations and why I believe they're wrong are that this is institutional and personal animus, the facts of which are detailed in the document before you. My other primary argument about why I think they're wrong is that this it was private First Amendment protected speech. The United States Supreme Court in Gentile versus Nevada gave the analysis that is used to evaluate an attorney's private speech, analyzing a professional rule of Nevada, I think it was that mirrors the one here. I do not stand before you as a First Amendment absolutist, and I do not I think there are scenarios in which a court can properly regulate an attorney's speech. Something that happened in the public domain was, the online bullying of a teenage actress named Courtney Stodden by a model and entrepreneur. I think if an attorney did that, they could properly be sanctioned.
Okay, so let's talk about you filing a civil lawsuit against the gentleman in Illinois and your prayer for relief.
Yes, ma'am.
Well exceeding the amount that you inadvertently transferred.
Yes, ma'am. The amount that I inadvertently transferred was returned to me some weeks after the initial transfer. My bulk of the claim exceeding the well in excess sum of the amount erroneously transferred is a defamation and other tortious claim stemming from Mr. Reynolds' lie-laden grievance. This court has held before in a case, I believe is Hecht v. Levin, that these statements enjoy absolute privilege. But I argue that this court should revise its stance on malicious or lie-based grievances being absolutely privileged. I was aware of Hecht v. Levin before I filed the defamation complaint and knew that I was arguing for a revision of the Supreme Court's divided 1991, opinion in that case.
Would that not have a chilling effect if that were to be overruled?
It would only chill malicious or lie-based grievances, Your Honor. Certainly, people should feel comfortable that they have somewhere to go when their attorney has wronged them. This was a guy. I wasn't representing anyone when I demanded this money back. So if these laws are meant to protect clients, Ohioans, and even the broader public, it shouldn't protect people who intentionally don't do the right thing.
But with regard to your case,
Yes, ma'am.
and correct me if I'm wrong, but you had Zelled monies two different times, correct?
Yes, Your Honor.
Okay, and each time it went into an incorrect account, albeit with the same name that your husband has?
As a result of my error, yes.
Okay. And this individual contacted his bank, and they then put it into the fraud, and then you received that money back within a 2-week period of time. So I guess I'm having a hard time determining where the malice comes in.
Well, it is in dispute, Your Honor, what steps the individual took to contact his bank, specifically the timing of that. The malice was in initiating the grievance with the Dayton Bar Association that was based on falsehoods. The initial claim...
What was the Dayton Bar Association? That wasn't the grievance, correct? As the chief had asked previously, with regard to your set of facts, your case, your grievance.
I'm sorry, I'm not following, Your Honor. Do you mind?
Do we consider your arguments with regard to anything other than what the grievance that was filed was about?
Well, the Dayton Bar Association's grievance, while it's certainly the claims that have, I think, emerged to the final phase are about the initiation of the civil claim. But the Dayton Bar Association has, throughout in its initial filing, asserted an array of other claims that do have a bearing with these kind of messy facts, and they are still advocating not for the 6-month suspension recommended by the panel, but indefinite suspension also based on those facts. I hope that's responsive. I have not been dishonest with anyone in connection with this matter. I was not, as suggested by a member of the grievance panel, consuming alcohol during my January 2024 Zoom appearance. I advised the Dayton Bar Association of the defamation claim against Mr. Reynolds in our first November 2023 meeting. I'd ask the court in my remaining time to consider the 365-day delay by the Dayton Bar Association in submitting this complaint. I'm not a psychoanalyst, but one notes that 365 days would have expired any tort defamation complaint if my claim accrued on September 27th, 2023. My claim accrued in November 2023, and so I refiled the civil case, at which point the Dayton Bar Association ratcheted up the stakes, if you will, as it has, I would submit, every time. When I've complained about the CLEs, it got worse. And then when I refiled the defamation claim, it got, nuclear isn't the word, but, the professional version of that anyway. All right, thank you.
Thank you. Mr. Roeder, good morning.
Good morning, Chief Justice. Chief Justice Kennedy, other distinguished members of the bench, may it please the court, I'm Paul Roeder, Jr., and I'm here today on behalf of the Dayton Bar Association. I'd like to spend a few minutes this morning talking about why I and my client feel that the conduct in this case warrants an indefinite suspension from the practice of law. I am a simple person, and perhaps sometimes I oversimplify things. And please accept I'd like to start simply by talking about the fundamental reason for everything that we as lawyers and judges do, and that's the concept of justice. This is a common word with a very important and consequential meaning. Merriam-Webster has the following amongst its definitions of the word justice: the quality of being just, impartial, or fair. In our criminal system, justice means a criminal is punished commensurately for the crime. It can also mean that someone wrongfully accused is cleared of any wrongdoing. In our civil system, it means disputes are fairly resolved. We have a U.S. Constitution, an Ohio Constitution, state and federal statutory and common law, administrative regulations, rules, all created in an effort to achieve justice as our society has defined it. Over the years, this court has repeatedly stated the primary purpose of the disciplinary sanctions is not to punish the offender, but to protect the public. There's a very strong reason for this court's stated primary purpose of protecting the public via the disciplinary process. The rules in this book, the Ohio Rules of Professional Conduct and Ohio's Code of Judicial Conduct, are not followed, how do we know we have justice as a society? If lawyers and judges are free to engage in ex parte communications, or if lawyers are free to take money from clients without doing work, or to have conflicting interest in representing clients, how can we as a society ever be assured that our criminal and civil courts can deliver justice? This book, in some ways, is the very foundation upon which our books that hold our statutes, our constitutions, and our administrative code rest. And
Okay, so let's focus on why the Dayton Bar Association believes that the appropriate sanction for the alleged misconduct is an indefinite suspension.
So, Justice Kennedy, the act of suing a grievant is a very serious act. It can have a monumental chilling effect on the bringing of grievances. And let's face it, if judges and lawyers are not held accountable, if they know that things are not going to get filed because of the chilling effect, because people are going to get sued and people are going to pay tens of thousands of dollars to defend civil lawsuits, then what check and balance do we have that lawyers and judges are going to file their rules? This, to me, is a very, very, it goes to the heart, it goes to the core.
So what if you have a legitimate claim against an individual who decides to grieve you before you're able to actually file your civil litigation?
So I'd like to quote from you two cases, Your Honor. These two cases, one from this court and one from the New York Court of Appeals, which is that state's highest court. Justice Moyer, in writing for this court, very eloquently stated the rationale behind the rule that statements made in disciplinary proceedings are absolutely privileged. He wrote, "Just as we held in Suris that the truth-seeking process in litigation demands free and unencumbered exchange of statements, so does the process of maintaining the ethical standards of the legal profession. A qualified privilege would open the door to retaliatory suits such as the one in this case and would chill the reporting of attorney misconduct. We believe to be overstated the warning that an absolute privilege will open a Pandora's box of grievances against attorneys. The attorney disciplinary process has been carefully designed to separate the wheat from the chaff. A grievance is kept private until a panel of the board makes a finding of probable cause and certifies it to the board. Investigation and independent review of a grievance occur at several stages before this court makes its own independent determination of discipline. These procedures assure that clearly frivolous complaints are summarily dismissed. For these reasons, we conclude that the balance between encouraging people to come forward with legitimate complaints and protecting attorneys from harassment is best struck by means of absolute immunity.
Okay, so I understand that. That's the precedent. Some would say that the world's changed a lot since then, that we live in an age where disciplinary proceedings, other things have increasingly become weaponized, used by people for for their political agendas or other things. Ohio has a statute already that grants a limited privilege for not just proceedings, attorney discipline, but medical boards, other professionals. Revised Code 2305.28, which creates a privilege where statements are made without malice and in the reasonable belief that the information is warranted by the facts. Why wouldn't that standard be sufficient? It would seem to apply here. I mean, it wouldn't prevent the discipline in this case.
So, Justice DeWine, I would point out the world has changed a lot. It's changed a lot in my short lifetime, which is just nothing but a new blip on the radar of humanity. But having said that, the idea that we as people require justice.
Well, but justice, justice works both ways, right? And I mean, it doesn't seem unreasonable to have a standard that says that if someone is privileged, if they make statements without malice in the reasonable belief that facts are warranted. I mean, should we be protecting people who make statements without a reasonable belief that they're true?
I think that the New York Court of Appeals said it best when they said, whatever hardship on a particular attorney, the necessity of maintaining the highest standards of our bar, indeed the proper administration of justice, requires that there be a forum in which clients or other persons unlearned in the law may state their complaints, have them examined, and if necessary, judicially determined.
But nothing about that statement would preclude the standard that the legislature's adopted.
I'll give you two examples of why absolute immunity, I think, is important to protect the sanctity of the grievance process. The first example is from 2019, and it involved the case of Payson versus Spivey in the Miami County Common Pleas Court. And in that court, in that case, Mr. Payson received a grievance from his client, his former client, Ms. Spivey. He sued the former client for defamation in the Miami County Common Pleas Court. The Miami County Court wrote, Spivey established that Payson filed the instant action in retaliation for ethics complaint to the DBA. Mr. Payson professed that he had other reasons for filing the suit, but the court said, I do not find Mr. Payson credible. Ultimately, the court awarded Ms. Spivey nearly $30,000 in sanctions. But despite that, from the record of the court, it appears those sanctions were never paid. And it appears that because there's no satisfaction of judgment entry that went on in the court confirming the payment. The Office of Disciplinary Counsel filed a disciplinary matter in that case, alleging that Ms. Spivey fell under arrears on her mortgage. Foreclosure action was filed due to the financial strain placed on her by paying attorney's fees to defend Mr. Payson. This was just 6 years ago. This is 2019.
But that's, the absolute privilege didn't prevent that from happening.
What did not prevent that from happening is there was not, I don't believe, a serious enough deterrence and the threat of a sanction for an attorney to engage in that kind of conduct. And that's a similar case to what's happened here. In this case, Mr. Reynolds from Illinois, through no fault of his own, receives $550. He reports it to his bank. The record is clear. There are statements from the bank in the record that say he asked for the return of that money. He indicated he opened a fraud dispute with his bank the very day the respondent contacted him. The money was returned within 2 weeks. It's all because Mr. Reynolds did that. But through no fault of his own, this gentleman is now stuck 2 years later in litigation in this state. He has paid attorneys over $21,000. How many people are going to come forward and report grievances if the public has a general idea that this is occurring? What judges and lawyers are going to report grievances? I mean, I have to admit, $20,000 would be a tremendous amount of money for me and my family. And I know I have a duty to protect the integrity of our system. But if lawyers are not sufficient...
Was she ordered to pay restitution for that in the grievance process?
So what the board recommended was that any sanction ordered by the common pleas court in her first case, she would have to fulfill before being reinstated. The problem with that is, for whatever reason, it does not appear that Mr. Reynolds asked for sanctions in that first case. Now, whether he didn't do that because...
It just puzzled me why the board would... Did you ask for restitution before the board? That's not your objection here.
Yeah, no, I did not specifically ask for restitution, but from my perspective, Justice DeWine, I think that this court is the court, obviously, that disciplines lawyers. I know there's some roles that some of the common pleas courts may play from some time here and there, but
it's tough for us to order a sanction when no one has asked for it, no one's objected. I've just been puzzled why she wasn't ordered to pay attorney's fees.
yeah, I can't answer that. But I think that the biggest concern that I have and my client have is that if we tolerate lawyers filing retaliatory suits for grievances, yes, it is going to chill the reporting of grievances. Look, we signed up for this job. We're going to get some bogus complaints against us from time to time. That's why the process is confidential until it gets to a certain stage. A lot of these things, as Justice Moyer pointed out, are weeded out. And it comes with the territory. You're going to get some of these from time to time. The important thing is that our system is protected so that we, as a society, know that lawyers are punished when they do something wrong, judges are punished when they do something wrong, and the public can report any concerns that they feel freely, without fear that they are going to spend tens of thousands of dollars, money they do not have, as a consequence.
Counsel, let me ask this. On the sanction, the panel and the board recommended 1 year, 6 months out, right?
Yes.
And you're asking for an indefinite.
Yes.
Why the difference? Even if I agree with the issue of immunity, why the additional indefinite?
So the panel likened this case to the Skolnick case,
Right.
which was a very despicable set of facts. You've obviously read the opinion, Your Honor. And what I feel that the panel missed in just focusing on that case is that the egregiousness of the conduct here was not the intemperate words said to Mr. Reynolds. That certainly, in my view, was not professional. The importance of this case is the retaliatory lawsuit. The retaliatory lawsuit is the one that can cause the most harm to our system. And in my humble view, the sanction needs to be stiff if we are going to protect the public, not from this lawyer, but from any other lawyer tempted to do this. We have 2 instances in the Dayton area, Mr. Payson in 2019, the respondent in 2023, filing grievances or filing lawsuits against grievance, costing huge amounts of money to these people. This is not the way the system should work. We should be able to freely report a grievance without fear. And if it's misreported or if it's made up, that's, it comes with the territory.
I hear you. I'm just trying to figure out why the difference between the 1 year, 6 months out versus the indefinite.
I equate it more to the LSAS case, the Columbus Bar
Okay.
versus LSAS. Now, there were other very bad acts of behavior in that case. Mr. LSAS was practicing after suspension. It's hard to tell from the court's opinion what part of that sanction was really related to the filing of the retaliatory lawsuit. I will note the dissent in that case wanted to permanently disbar Mr. LSAS, so they wanted a much serious sanction. I think this case presents the opportunity for the court to enlighten the members of the bar and the public as to what will happen if a retaliatory lawsuit is filed. And I see my time is up, and I thank you all very much today.
Thank you. Ms. Baker, you have 38 seconds remaining.
I'll use my 38 seconds.
Okay.
Okay. The relator describes my lawsuit as retaliatory, and that hasn't been my intention, and I wouldn't characterize it that way. If it's I would say that it's in consequence of these malicious actions. And the relator said that the pre-probable cause finding stage is confidential, and that is the case unless they tell you that they're investigating you. The reader of passage 2 wrote me weeks ago threatening me with professional discipline for statements filed in my objections to you in this case, which were 100% true. It continues. Thank you.
Thank you. We'll take the matter under advisement. You will receive a decision from the court martial. Close the court, please.
All rise. Hear ye, hear ye, hear ye. This open session of the Honorable Supreme Court of Ohio now stands adjourned.